Really excited about today's topic, really super important. Thank you ahead of time, Golan and Jonathan, for giving us an hour of your time over the lunch hour. And also thank you to our articling student, Stephanie. It's almost like I just called you a few minutes ago. Hey, what are you doing? You want to do a live event?
Yeah, just thrown into the fire, but it's
That's
great.
right.
I love doing these.
So what are we talking about today, Steph?
Yeah, so I'd like to welcome everyone and thank you for joining for today's presentation. As Russ mentioned, my name is Stephanie. I'm an articling student at the firm. So today I'm going to start with some introductions, let you know what we have on for the agenda, and then I'll pass things over to our panelists. So you will notice that the chat box has been disabled to ensure attendees remain anonymous to other audience members. However, if you do have any questions for our panelists, you can send them through the Q&A. And I apologize in advance if my dog is barking in the background. She's old and she's deaf and she doesn't realize how loud she is.
Is that one of the dogs, one of the care dogs you've taken in?
No, so my personal dog is back. No more fosters for now.
Oh, okay.
So just a heads up for everybody, please keep in mind that this presentation is for general information on the topic of the Voice of the Child report in family law and should not be considered as legal advice. So in this 1-hour presentation, our panelists will be talking about the following topics. So what is the Voice of the Child report? When, before, or during court, anytime? Who prepares the Voice of the Child report? Private versus the OCL, the how, the weight, so the treatment by counsel, parents, and judges, screening, the child's right to counsel, and challenging the Voice of the Child reports, as well as some case law. So there will be a Q&A segment at the end of the presentation. So if you haven't already, please feel free to submit your questions via the Q&A box, and we'll do our best to get to your questions during the presentation. We'll also be providing links to helpful resources mentioned throughout the event in a follow-up email, so keep your eye out for that. So now it's my pleasure to introduce the hosts. So we have Jonathan Paynter. Jonathan is a registered social worker and psychotherapist who works in the family court system. He completes a variety of assessments and youth court assessments. He specializes in cognitive behavioral therapy and couples counseling and holds certificates in collaborative family law, advanced family mediation, family arbitration, domestic violence screening, offender relapse prevention, and assessment of risk. So Jonathan's got a lot of history behind him. So next we have Golan. Golan is an associate family lawyer and certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients and negotiation agreements as well as trial work. He also has experience in negotiations with the authorities to advance a client's interests and have represented clients at a variety of different levels of courts, including on appeals. And last but not least, Russell Alexander is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell uses his knowledge and expertise in collaborative family law with a client-focused approach by creating unique solutions for each of his clients. So now that you know a little bit more about our panelists and what we have on the agenda for today, I'm going to pass things over to you, Russell, and get this train rolling.
Get the party started.
Get the party started.
I think the next slide is our Zoom divorce. So we're giving away this free at the end. If you, there's a couple things we're going to ask of our audience members. I want to thank everybody for attending today. We really appreciate all the questions that were sent in advance. We've got some great questions. We encourage everybody to send us your questions through the Q&A. We're going to answer as many as we can throughout the program. We have some time slotted at the end just for questions and answers, so please send us your questions. Also send us your feedback. What's working, what's not. It helps us design this program so you can get the most out of it. Most importantly, Steph, can we offer our guarantee today?
Of course, as always, we would like to offer our money back guarantee on our free webinar. So if you do want to take advantage of that, just let us know.
How do you get your money back? You got to send in a coupon or something at the end, or what?
Yeah, answer the questionnaire at the end. There should be one that pops up in your browser.
All right, let's get going. Let's start off with the poll because we love the polls. We're gonna have some polls throughout. Please send us your responses. It helps us understand our audience better. So our first poll, what is the reason for joining us today? In the legal profession, in a different profession, currently going through a separation or divorce, have a loved one going through a separation or divorce or other. So we're going to give everybody just a moment to get your answers in. But I've got a question that was sent in advance. I'm going to give this one to you, Golan. So if you can give us your feedback. What's the process? How's the process or an application made or the procedure if you want to appoint a lawyer for the child? We're going to talk about this in depth, but generally speaking, how do we get a lawyer to give us the voice of the child?
Firstly, thank you for having me here, Ras, and thank you for the question. Be happy to answer that and give some idea of how this happens, how it unfolds, whether it's in the court system or whether it's outside of the court system. It actually relates to the topic of when we actually asking for a voice of the child and what it is. So perhaps the idea is first to understand what is it, what are we trying to get with the report. Okay.
I'm going to hold you right there. Just hold that thought. Let's see what our audience response is. All right, 55% law professional, 26% other field, 11% going through a separation and divorce, 3% here for a loved one and other, put in the chat box. So heavily weighted on the professional side. Sorry, let's get into the first slide, and this is going to actually answer our question. So this is your slide. Just go ahead, Golan.
Yeah, so talking about what is it, generally, what we're trying to achieve here is getting the child's views and preferences as it affects his parenting time. We try to achieve their, see their perspective, concerns, any consideration that the parents should be taking into account, as well as judges or other professional who may be assisting the parties in forming or formulating a parenting plan. There are things that sometimes we don't realize that coming to children, we're not even telling them that the parties are separated, but all of a sudden they are meet with a parenting plan that they did not have a chance to give their input, especially when they're able to do so. So the voice of the child report meant to be a non-evaluative report that is giving us that background information about the child's views. And it normally, like I said, it can assist the lawyers, it can assist the judges that can request the preparation from either the Office of the Children's Lawyer. So when you see here, it says OCL, that's what we're referring to. And or privately, it can be done privately, it can be done before litigation even started, during a mediation process, during time that the parents are considering their parenting plan and they wish to know more. What we need to understand is that the voice of the child report came out of the idea that children have rights, and those rights are, we can see them in the United Nations Convention on the Right of the Child. It's actually in Article 12 of the convention, and that convention had been ratified in Canada. So we are relying on the articles of the convention to enforce the idea that the children are entitled to their input, and if and when a child is able to give his input, they should be considered and approached. Again, depends on the maturity level, depends on the age, depends on other factors that would assist ascertaining the views and preferences, and not just because a child wants to say or have something to say. For that purpose, the Judicial system has to accommodate, or at least consider, that would be a better word, consider the obtaining a voice of the child, especially in custody matters, well, parenting cases that are before the before the judge, or when parents have to deal with it. So this is the idea of what the voice of the child is, and when normally we try to obtain the voice of the child report is basically can be done at any part of the process, post separation or even before separation, depending on what the parents are trying to achieve. Are they using an alternative dispute resolution to to the breakdown of the marriage and the separation, or whether they already started the court process and there's a more need for input and understanding of what is and what would be in the best interest of the children. And sometimes it's better to get the understanding directly from the child once he's been interviewed, and then that information can become available to the parties, the judge, the lawyers, etc.
All right, let's do another poll here. Thank you so much for that, Golan. Poll number 2, how often is the voice of the child obtained? In every dispute, only when the parents are asking for it, in every case when a judge orders it, or in a case when the Office of the Children Lawyers accepts the appointment or the parents retain a professional to conduct same. So give everybody a moment to get their answer in. I got a quick question for you, Jonathan. What about children with disability? How do we address that when we're considering a voice of the child input into a family court matter?
Great question, Russell. And the person doing the voice of the child, whether it's a lawyer or a social worker, really has to assess the child's age and stage of development. And there are some disabilities that might impact their development or their intellectual ability. And so one of the questions that people doing voice of the child reports should ask themselves is, how is this child able to provide their voice? Are they able to maturely understand the situation in their family, or are they too young to do that? And so that's always a question that should be asked and answered in the report.
Too, right, Jonathan?
Yeah, exactly. Yeah.
Is it affecting cognitive skills, or if it's...
Yeah. For example, some of my clients who are children who have ADHD, for example, can't handle a Zoom interview. They just get too distracted, and so you really have to have them in your office. So you also want to design the process based on the needs of the child, and accommodate whatever disabilities they have. Yeah,
got lots of questions coming in about the age of the child. We're going to get to that in our program, but let's see what our poll results are. So a clear majority in every case when it's ordered and the Office of the Children's Lawyer accepts the appointment or orders that the parties retain a professional in terms of how often it should be obtained. I guess their views can change, right? Their views at the beginning of the litigation might be different when it comes to trial time. So you might want to update the report as well. All right, so let's take a look at when, before, during, or any time. Golan, when do we get these reports? I kind of alluded to it a little bit, but what have you been seeing?
Right, so thank you for that. It just a follow-up on the previous topic when we said, when do we normally use the voice of the child report? And like I said, it can be used at any point from the separation onwards, depending on what route the parties have taken, whether it's an alternative dispute resolution that they need to formulate a parenting plan and they would like to know to obtain some views and preferences, or what is the children's concern before they make that decision on how the parenting plan is going to look like. Another situation is like you mentioned. I mean, it can be anytime during the litigation from the start, and then things come up during the course of the litigation that the parties would like to obtain the views. So one party may suggest that the child is concerned about going to one parent or the other way around, and you know, maybe there is issues with exposure to relatives, to activities, to anything that might come up, and is not very clear, because at that point you only hear it from the parties, and then a judge may want to have a clarification, want to hear it directly from the children, and may want to appoint a professional to assist in obtaining the report, the voice of the child report. So like I said, it could be done at any time of the process, all the way through the trial.
And, you know, you don't need to wait to go to court to get a voice of the child report. If you're in a collaborative process, you can agree to do it privately. Oftentimes, counsel will arrange for a private voice of the child report, and that report will settle the case, right? Usually the parents will respect the child's wishes, whatever they are. I guess the advantage of doing it through the court system in the office of the children's lawyer is the government's going to pay for the process. Where privately, you're going to be doing, we're going to talk about costs in a bit, but a few $1,000s at least, I would suspect. Thank you for that, Golan. Who prepares the voice of the child report? Jonathan, what can we expect? How does that look like? What in qualifications? What should we be considering?
Yeah, so various professionals can complete these reports, and I would suggest that people look for certain qualifications before they go ahead. One is, I would recommend that they have a degree in a related field, so social work, psychology, psychiatry. Sometimes lawyers do these kinds of reports as well. Typically, I would look for someone with a master's level degree or higher, but I know also some excellent practitioners who have bachelor's degrees. Generally, the more qualifications a person has, the more expensive it's going to be. And you want to look for someone too who has training with kids. Interviewing kids is very different from interviewing adults. And I would recommend that you look for people who have either taken a course. For example, the Ontario Association for Family Mediation offers a course called Child Inclusive Mediation training, and that helps practitioners learn how to ask questions to kids in a way that fits their developmental ages and stages. There's also courses on parenting assessments offered by the Association for Family and Conciliatory Courts, which are excellent. And there's a lot of private trainers offering courses in this field as well. So look for someone who has that background. Look for someone who's experienced working with kids and who knows about the difference between child psychology and adult psychology. So, for example, it's really important that the interviewer, the person doing the report, knows that young children have a very poor sense of time. So they struggle to tell a linear story with a beginning, middle, and end. And they often engage in magical thinking. So they may say something that, you know, makes sense in the time, but you're not really understanding the context. Just to give you a quick example, I had a kid that I was working with in counseling tell his mom a few weeks ago that he was bullied at school yesterday, and he's in kindergarten. And the mom, you know, called up the principal of the school and said, you know, I'm furious, you didn't tell me about this. And the principal said, well, no, this incident happened months ago, and we did talk to you about it at the time. And he's referring to that incident that happened months ago, but kid couldn't work out in his mind whether it happened yesterday or a few months ago. So knowledge of child development is really important for that. I would also recommend you pick someone who's a professional member of a regulatory body. So, you know, the Law Society of Ontario, College of Psychologists of Ontario, the Ontario College of Social Workers and Social Service Workers. These regulatory bodies are designed to keep their members accountable for their professional action, and they can be disciplined if they mess up or don't do a good job as an assessor. And then finally, I would recommend you just do your homework. Like, talk to the person who's being recommended, find out, what their experience is, have a conversation with them, see how you feel about them. And, it's really important to pick the right person, because once the person's picked, you're kind of locked in. So do your homework, do your due diligence, and find out what their qualifications are. And, sometimes it helps to get a bunch of different names and pick one from the list to see which one's the best.
Great stuff. Let's run a poll, because we know I love the polls. So how much would a voice of the child report cost? And there's multi answers here. None if it's done through the OCL, 50-50, proportionate, depends on how many children there are, in a range, and then the judge decides. So we'll give everybody a moment to give us an answer to that. Really excellent questions coming in. Thank you so much, everybody. One that just came in online. How and why can the OCL refuse a case when ordered by a judge? I don't understand why it is an option for the OCL. Well, the judge requests it of the OCL. The OCL has limited resources, so they can't take on every case that's sent to them. A few years ago, you needed to establish if there was clinical issues before the OCL would get involved. And now voice of the child reports seem to be the flavor of the day, and they're much more common. But I've got another question came in online. I want to try to see if we can get to it. And either of you guys can take a crack at this one. Will interviewing the children really help a judge on custody and access issues? What training should judges receive before they interview children? I've got a great story about judges doing judicial interviews. If we have time, I'll get to it. But Golan, what do you think of this question?
Well, the question whether it assists a judge in getting the views of a child, I think, again, it depends. The answer is always the same. It depends. It depends on many factors. It depends on the ability to ascertain the truthfulness of what has been reported, the weight that would be given to that, to that report, to the views of the child, understanding whether there was influence or not, realizing that what the child wants is not necessarily what he needs, and not necessarily equate with his best interest. So to say that it's automatically being accepted and being a valued and giving weight to the maximum extent possible, it would not be the correct answer. I think it really depends. It definitely helps. I think judges to understand, who's behind, the name on the paper, and to get to know more the dynamics, and what influences are out there to come up with what would be in the best interest of the child. So I definitely think that, in the right constellation, and when there is really a clean report that can be given a proper weight, it could be very helpful.
And there's some due process issues as well, right? Are we going to do in the judge's office at the courthouse? Is the judge going to go to the school? What role does counsel play? Can the judge relay to the parents what the child says, or is that confidential? So there's a lot of issues surrounding judges doing interviews of children and their training. But let's see what our audience is thinking on this poll question. All right, so 63% no cost if it's done through the OCL. That's right. I guess there could be some costs in sense of delay, right? Procedurally, you need to get through a case conference, have the request made. It might take a few months down the line. So it could cost you in terms of time, but finances is definitely more efficient. 50-50, proportionate, but equal there. Depends how many children. We're going to talk about that as well. Fairly evenly audience answers across the board here. So thank you everybody for submitting those. Private versus OCL judicial system. What do you think here, Jonathan? What are we talking about?
Yeah, I think the OCL tends to have a narrower focus, and they only interview the kids, and they only report on the views and preferences of the children as the children report them. I think OCL, Voice of the Child reports, and other public agencies that offer that, like the Kawartha Family Court Assessment Service in Peterborough or the London Family Court Clinic in London, tend to take a bit more time because they have an intake process. They usually have a wait list. They're usually a little bit more cost effective, and particularly the OCL, but you might be waiting a long time. And with the OCL, of course, the delay might be that you get the referral to the OCL and then they say no, and then you're back to square one and you have to look for a private person or look for one of these other public agencies to do the report for you.
Or one parent sends in the form and the other parent doesn't. Right?
Yeah, that happens a lot for sure.
We actually have a question right on this point.
Oh, perfect.
How long normally does it take for an OCL to respond? What's your experience been to respond to request?
I don't make the referrals, and I haven't worked for the OCL for quite some time, so I'm not really sure what the process is currently. Do you, Golan or Russell, have any experience with?
I actually, from my experience at least, I find that it takes them a few weeks before they come back with an answer.
Okay.
On a recent case of mine, I actually had to ask to appeal it in order to have them reconsider in a very high conflict matter that they decided to not take. And it sometimes like the audience were questioning how come they refuse an appointment. I was amazed by that refusal of a very high conflict that really called for it, and then it came back as a refusal. But eventually it was sorted out and they actually picked it up. And I think it was, and it's still in the process of being very useful to obtain the voice of the child in that matter. So yeah, a few weeks is at a minimum that I find before they come back with yay or nay. And after that, there's a whole process of whether you're asking for reconsideration. I saw judges that asking more than once and more than twice.
Yeah.
To
pretty please.
Yeah, really appealing to them. Please take. I mean, what else can I say? I mean,
yeah.
But that's the sad part.
But if they deny, if they deny the request at the OCL level, you can still arrange for a private assessment, right? If you have assessors in your community, and lots of them are really, really accommodating, I find. Sorry, did you want to wrap up this point? I kind of cut you off there, Jonathan.
Yeah, just to say that if you wanted to go with a private person, you're probably going to have a little bit of a faster process, but it really depends on the practitioner. Some people are super busy and you might have to wait a few months to get on their roster. So there are advantages and disadvantages of either one.
Okay, thank you for that. Well, we haven't done a poll for a few minutes, so let's get back at it. What is the effect of the voice of the child report? And you have a couple of options here. It determines parenting each time. For each parent, parenting time is for information purposes only. It provides the judge with another aspect for determining parenting, and the court must accept the report as it comes in. So we'll give everybody a moment to respond to that. See if we can throw in a couple quick questions. How many reports can a child have during a case? So I guess really, can it be updated? Do you get a fresh report later on? What's your experience been, Jonathan?
Generally, no, but I have had some experience recently in just the late winter this year, where I prepared a Voice of the Child report for court, and there were still a couple of more questions that hadn't been answered. So they asked me to re-interview the child and answer those specific questions, which I did. So sometimes they'll ask you to come back with a little bit more information, but usually, judges want to avoid ordering too many of these. And when an assessment or a voice of the child is out in the court documents, they don't want to keep going back and reevaluating every issue, having new assessment or voice of the child report every time a new issue comes up, because it just gets too demanding for the family, too expensive, and it really delays the process.
Right.
And it can be stressful for the child too.
Yeah. Let's get our poll answers up here, our results, and I'm going to do a quick question that came in ahead of time. If the judge orders complete an OCL application, the opposing party does not fill it out, what consequences may follow if the OCL doesn't get involved because somebody didn't fill out the form? My view is if you're not filling out the form and participating, it's going to go very badly for you, and the judge will likely not consider your position with respect to parenting because you're not complying with the court order. So that would be my take on this. Let's see what our poll results are. Provides the judge with another aspect for determining the parenting and best interest of the child, 97%. Clear majority on that one. Thank you everybody for sending in your answers. So the how, what are we looking at, Jonathan? How do we go about, what are the nuts and bolts of putting one of these voice of the child reports together?
Yeah, great question. And I'll go back to Golan's answer. It depends. Different practitioners have different processes that they follow. For me in particular, what I usually do is I'll interview each parent once to find out, what are the questions that they're wanting answered, and get the parent's perspective on those issues. That parent interview can also be helpful to see if the children have been influenced by the parent. So, for example, if the parent says, I want a 5-5-2-2 schedule with exchanges at 4:30 p.m. and then a 7-year-old comes, when I interview them, says the exact same schedule, maybe I'm thinking there's some parental influence there.
I want my dad to have 41% parenting.
That's a good one.
How's a 7-year-old come up with that, right?
Exactly. And then I would interview the kids each twice at a minimum. Once when they're with the one parent and once when they're with the other parent. That way you can gauge, like, does their opinion change dramatically depending on who the parent they're with? And that also can be a sign of parental influence. So it's good to have that balance as well, where you're not only seeing the child being brought in by one parent. Sometimes, depending on the case, I'll also look at things like report cards, or sometimes kids will have psychological assessments that will kind of help me understand their developmental level, or if they have any disabilities like ADHD or autism, those kinds of things, and it will help inform me how to set up the interview and speak with the child. And then generally after that, you would be writing up a report, or sometimes I'll host a disclosure meeting at the request of the parties, where I meet with them and their lawyers and just discuss the findings of my interviews and try to help the parents come to a settlement during that meeting.
We're getting lots of questions about age, and we got a poll coming up, so just hang on to those questions. We're going to get to them. But let's go back down to some basics here. We've got a question. What's the difference between an OCL report and voice of the child report? Is one better than the other? Jonathan? Pretty much the same thing.
Yeah, it's pretty much the same thing. I wouldn't say one's better. I think the OCL has stricter guidelines as to how they conduct the process, whereas when you go with a private practitioner, you'll see a little bit more variety, but there are some standards that you'll always see or always should see. If you don't, you should raise some questions about that. But the main one is interviewing the children twice, once when they're with their mom and once when they're with their dad, or depending on the parents, it could be if there's two moms or two dads. You want to make sure you're interviewing the kids once at each home, or once when they're at each home.
And being delivered, I guess if you're doing it for the court, you do a written report. Sometimes parents like a verbal report. They want to keep the expense down.
Yeah,
What's
exactly.
your experience and how the report's delivered, Jonathan?
Yeah, most people want a written report and a verbal report, so I'll do both. And like I said, the verbal report's a great opportunity for us all to sit down and try to work out a resolution to the dispute and come up with a plan that works best for the kids. And I've seen a lot of parents really surprised with what they're hearing from children and dramatically change their position based on that. And that's a real testament to, parents wanting what's best for the kids and maybe not knowing how to get it. Because what often happens, you get this dynamic where child A will tell parent A what they want to hear, and then when they're with parent B, they'll say what they think parent B wants to hear. So both parents come into this process feeling very empowered that I know what my child wants because that's what they've been told. But when you get a neutral point of view, sometimes you get a different perspective, and the child's not trying to influence you or make you happy, so you can get that neutral point of view that can be really helpful.
And when you do an oral meeting, those could be tough meetings, right? Like it could be a punch in the gut for a parent. Little Johnny doesn't want to see mommy or daddy. It's like, wow, that hurts, right? When they hear it for the first time from a neutral party, not a member who's participating in the litigation.
Yeah. So, when I do child inclusive mediation, for example, I do a lot of prep with the parents before I start interviewing the children, just helping them understand, that it may be hard for you to hear this information, and it's really important that you're prepared to hear whatever the child has to say, even if it doesn't align with what you're thinking right now. Right. So that preparation can be helpful.
My experience, most child-focused parents accept the view and change their stance and settle the case fairly quickly after we get these reports in. Thank you, Jonathan. So let's go to weight and treatment by counsel, parents, and judges. So how much weight do we give these reports, Golan?
Oh, that goes back to my standard answer. It depends.
Come on, we've got to answer some questions here.
Where's your PowerPoint page that says it depends?
Yeah, that's what's missing. Well, it's all
You've
over
got the magic 8 ball, right? This is the answer to your legal question today.
It's the first course you take in law school. It's 101. The answer is it depends. And in this context, really, we spoke about it. We already touched that area of the maturity level, the idea of once you did the screening, whether there were influence one way or another. Speaking of which, you guys have mentioned some influences. I had a kid that was being interviewed wearing #1 dad while he was interviewed. I thought that was something that the reporter was actually found it necessary to report on the Voice of the Child report, where normally they just tell you what the child said, but not what he was wearing. But that was a clue, I guess, and nuances that the judge need to take in and consider. And like I said, so it's the treatment by parents could be from accepting it, like Russ and Jonathan just mentioned, that it comes down to they accept what they heard and they go by it and they formulate the plan in accordance with that views and wishes of the child, and that resolve the matter. Counsel can be providing their assistance in the analysis of how they see the report coming across, whether it has the ring of truth to it, that it actually came across as clean and there's no influences, and advocate one way or another if the weight of the report has to be given, greater weight or lesser weight. Judges, of course, will do the overall assessment and decide whether they should really go with the views and the preferences of a child. Again, at the end of the day is how firstly, what is the issue that is in dispute here, and how significant and ascertainable that view comes out from the child's perspective. So again, at the end of the day, it depends.
I've got a great case we're going to talk about at the end that goes directly to weight, so stay tuned. So next we're going to talk about screening. But before we do that, there's a question that came in I want to give Jonathan a chance to answer. How do you handle stage interviews in a parent's home? Often all too often, craft time, game time is planned out. We know this isn't reality. How do you come up with a perspective in these situations? It does seem kind of artificial, right? we're going to do craft time and some strangers watching us interact. Like, that's got to be a lot of stress on the parents to go through that.
Yeah. So different people handle this differently. I know up in Peterborough at the Court of Family Court Assessment, they actually have people come into a playroom that has a one-way mirror and a microphone. So it's even a little bit more intimidating for families in that situation. So, different people handle it differently. For me, I like to allow things to unfold a little bit more naturally. And now keep in mind that with staged interviews and visiting the home, you're more talking about full parenting assessments. And I wouldn't necessarily do that for a voice of the child. Usually for a voice of the child, they're coming into my office and I'm seeing them alone or on a rare occasion with their sibling.
So thank you for that. Let's talk about screening. What do you do, Jonathan?
So I think the sort of background question of this is about, what happens if one parent is trying to influence the child's comments in the voice of the child report. Now, if there's severe parent-child contact problems, like one parent's being rejected by one or more of the children, I wouldn't necessarily recommend voice of the child report as a good option. I would suggest you go a little bit deeper and get a full Section 30 assessment, because that will give the assessor more opportunities to look into parental influence and really dig deep into the reasons why the parent's being rejected by that child. And usually things are pretty complicated. Usually parents will say, well, it's the other parent doing it, but almost always, not 100% of the time, but almost always it's a little bit more complicated than that. There's some complicated dynamics going on there. So we sort of briefly mentioned a couple of things that we look for. If a child is saying the exact same thing a parent is saying, that's pretty good indication, especially if they're suggesting things that are beyond their developmental level to understand. So if a child says, I want to spend about equal time with my mom and dad, that's cool. But if they're saying a specific schedule, well, I want to see my dads on Wednesdays and Thursdays and every other Friday from 4:30 till 2:30 on Sunday, that's probably a good example of a parental influence. Not always, but particularly with the younger child. Older children, teenagers are more able to understand schedules, and they might want to throw in other things like their work schedule or their sports schedule. So you just want to assess the level of their development and whether their comments fit that level of development. It's also helpful, like I said, to interview the child's parents first, obviously separately, because then you get an idea of what the parents' opinions are on the subjects that you're talking to kids about, and that will give you a better opportunity to assess parental influence. Ultimately, it's not a perfect process. There's no machine I can stick on the kids' heads to know exactly how much influence they've experienced. And also keep in mind, child's memory is very malleable and very easily influenced by children, or by their parents, even by just suggesting things. Right. So it is definitely something to look out for.
Thank you for that. Let's go into our final poll question of the day. And we're getting lots of questions on this question throughout the chat. So thank you everybody for sending in your questions. What age should the court have to consider the voice of the child? 0 to 5, 6 to 12, 12 to 15, 16 plus, all of the above, none of the above, or when they start looking after their parents. So we'll give everybody a moment to put your answers in. Thank you for participating in the polls today. A lot of the information we're providing you today is going to be sent to you in a follow-up email with show notes. So you get links to some of the cases and the resources that we're talking about here today. So thank you again for attending. Let's see what our audience thinks. All right, so all the above. That's a pretty good answer, 52%, 12 to 15, 22%, 6 to 12, 19%. 0 for 0 to 5, well, obviously not much of a voice there, and none of the above. So thank you everyone for participating in that poll. The child's right to counsel. We need to be mindful of this, right, Golan?
Absolutely. Firstly, the right to be heard is like we said, it is entrenched by the convention that was ratified. We spoke about the Children's Law Reform Act, specifically Section 24, that provides for obtaining the views and preferences. A child has the right to counsel, and normally, if we do it by way of asking for the appointment of the Office of the Children's Lawyer, that is one option. There's nothing to prevent a child to hire a private one, so his parents are obviously retaining one, or even through legal aid. Normally, you see that happens under the protection cases, when you have the child that has his own lawyer. Similarly, like I said, it could be done privately through legal aid or through the appointment of the Office of the Children's Lawyer. So that is it's there. It's available. I did not see a situation where judges were suggesting that a child's lawyer should not be heard if he has, obviously they have standing and they should be able to speak up on behalf of their client, especially if this client is affected by any decision that is going to be made. If it's not a relevant case for the child, then obviously it may not be obtained. But in terms of a right to counsel, it's obviously there.
All right. We've had some questions come in on this next topic, challenging a voice of the child report. All right, so we got a report, we don't like it, or our client doesn't like it and instructs us to press on. How do we challenge these reports, Golan?
Well, so there's basically two major routes that you go about challenging the report. The first one is you're asking to cross-examine the reporter, the person that was conducting the interview. That becomes part of the evidence of the weight to be given to the report, right? I mean, once you have the transcript of the cross-examination, that is an added facet to the overall assessment of how the report was conducted, whether the questioning was guided, whether there was a lack of awareness to parental influence of any kind, and so forth. That by itself is, is a challenge. But the other option is that you bring your submissions before a judge during trial as to what weight should be given to the report if you did not have the chance of cross-examining the reporter. So that's another option of challenging the report. And at the end of the day, even the cross-examination itself can assist you in making the best submissions to challenge the report when the time comes to make your point about what weight should be given to any child report.
Can I make a quick suggestion too?
Mm-hmm.
One thing that's lawyers have been starting to use me for is to critique these reports as well.
Right.
And if my critique can't be taken to court, the judge will usually reject that, but I can, or someone like me can give advice to the lawyer saying, well, it looks a little weak on this, or they didn't do that, and give the lawyer some suggestions on questions to ask in cross-examination. So it's a little tip there. That's
a great tip for preparation. It'd just be like challenging any expert, right? You look at the assumptions, the questions they asked, the documents they reviewed, the witnesses they talked to, or the parents that they talked to, and how many times. I guess if the author of the report only talked to one parent, not the other,
Yeah, that's a good
an
example.
issue
Yeah.
for cross-examination as well. So very important, especially if your client disagrees with the voice of the child report, to consider what other evidence or what questions you want to ask the person who prepared the report. All
Yeah,
right.
and
So
generally, the court won't accept
critique.
well, not even just a critique, but if you go and get your own assessment separate from that to try to challenge the first assessment or voice of the child, the court will usually reject that.
Right. Good to know. All right, so let's talk a little bit about some case law, then we're going to get into some more Q&A. But let's just, before we get into case law, there was a question that came in ahead of time. Bringing a child into conflict can have a negative impact on children, psychologically speaking. In what circumstances do you think it's inevitable to get input from the children for a voice of the child? And when can it be avoided? Jonathan, what do you think of that question?
So there's actually a really good article written by Dr. Rachel Birnbaum and Dr. Nick Bala, who are kind of gurus in this field of divorce and separation. And they wrote an article about 5 years ago, I think in 2017 maybe. And they have done some research that shows that children generally benefit from their voice being heard in court. The children feel better about whatever plan gets put in place after that if their views and preferences have been gotten and heard by the court. So I would say on balance, it's generally a positive experience for children. It can be stressful, but it's a lot less stressful than the conflict between the parents. And if you can resolve that, having a couple of interviews with a person like myself is a lot less stressful. And I do my best, and I'm sure other practitioners do as well, to make the kids feel comfortable. I weave in serious questions about parental conflict with also fun questions like, what do you like to eat? What are your favorite movies? What kind of video games do you like to play? I like to joke a lot and make them laugh so that when they leave the interview, they're not feeling like, oh my God, that was a horrible experience. I feel really stressed, but they feel like, yeah, I think that person really understood me, and I'm happy that I participated in that. So as practitioners, we want to do no harm. So if we sense that the child is super anxious or doesn't want to talk to us, or that we're going to do harm by engaging them in that process, we'll maybe think twice about it.
With respect to anxious children, right? How do you approach that when it's clearly the child's stressed by the whole process?
Yeah, I deal with anxious people, both children and adults, all the time. So again, you want to find someone who has a lot of experience working with people who struggle with anxiety. And again, I start light to help them feel comfortable. I ask them questions about school and their pets and their favorite toys and what their stuffy's name is and what they do for summer, what they dressed up for as Halloween. I ask them about, Christmas, what happens when Santa visits your house, or other important holidays. So, you do your best to try to engage them in a conversation. It's not use, as a like a police officer investigating a crime. You're engaging them in a happy conversation that does have some more serious and stressful questions, but it also has some fun and lighter questions. So I generally find that works well for kids.
Try to build a rapport. Great tip.
The rapport is so important.
What does a court do? One parent stands up, says, I want a voice of the child report. The other parent doesn't. There's no agreement. So it's not on consent. What do you often see the court doing?
Well, obviously, and that actually falls into one of the cases that is going to be reported there.
All right, well, let's get on to the cases. Good lead in.
Good lead in, yes. I just wanted to comment before that on Jonathan comments. The premise that we're working on here, in obtaining the voice of the child report, has to be based on the child wanting to give his voice to be heard. We forgetting that it's really the child's consent. It's his right to be heard, and without his consent to be interviewed, you will not be achieving the goals. I mean, prompting a child to speak up and say his mind or whatever is on his mind. I guess, again, depending on the ages, at some ages they don't really want to say anything. At other ages, you need to prompt them to say some more, and some of them would be more than willing and happy to voice their opinion. On the case law, you can see that one of the things that I thought was kind of representative of what happens when one parent wants a report, the other doesn't, because one thinks that he knows what the views of the child is, and he can get that supported with the views of the child report, and that can bolster his position. And then the judge in this case that you see reported before, I think it was the Justice Kitely on Gandna and Canepa. So you can see there that in this case, the judge says, well, it's a 15-year-old, and normally we should be able to, it should be assisting the court to know what, what the child preferences are. But in this case, it found that it was not going to be ascertainable. So that actually comes from the second case, not from this one. This one was actually talking about why the report should be assisting, even especially in the cases where parents are in agreement. When there's no agreement, one can bring a motion, and a judge will decide whether a voice of the child report is helpful or not. And that's where you come. If you flip over to the next case, you will see a situation where a motion was brought in, and the 15-year-old child was fed up with all the questions. That's the reason the OCL has been involved in the case for a long time, and the judge decided that he's not going to let this continue, and therefore declined the report. So that shows you that you can bring a motion to the court, especially if a child wants to provide his opinion, it's probably going to have more weight. But if it's going to just inflame the situation or not be of assistance, I don't see judges simply ordering this just because the right is there. The right is there, but it's eventually the consideration for a judge to decide if it's going to be helpful for the process or whether it's just going to be distracting from it or causing more harm.
Let's go to the first slide, Steph. I think it was SL with the case in it. One more. Yeah, so I really like this quote. I think it kind of summarizes really the last hour of our discussion in one paragraph, if that's possible. In many cases, family court judges often make determinations as to how much weight to be attributed to a child's stated preferences based on a lot of predictable factors: age, maturity, clarity, context, consistency, potential alienation or influence, the strengths of those views and the thinking behind it. I think that neatly summarizes, what use you can make of these voice of the child reports in terms of doing this analysis and trying to put it into context. We all have very mature 12-year-olds and very immature 15-year-olds. Every child's different. So I think that's a good way to anchor this program. Our host is back. Welcome back, Steph. We may or may not have time for a couple questions, probably maybe just one.
All right, so just before we get into that question, I just want to let everyone know that a survey will be popping up in your browser following the webinar. So please, if you have the time, we welcome and appreciate any feedback that you have from today's session so we can take it into consideration as we continue to grow our virtual event series. One of those questions will be to share your thoughts on topics that you would like to see our team discuss in the future. So please let us know your ideas. And as a sign of our appreciation, we will be providing a complimentary advanced e-copy of Russell's new book on Zoom divorce. So let's get into some Q&A. Let's see what we have here. Russ, do you have any that you'd like to discuss?
Yeah, I've been kind of picking away at these. Let's wrap up with this one. What is the weight, now that we've gone through all this, that you think a judge will give a private voice of the child report as to a report done through the OCL? Jonathan, thoughts?
In my experience, they give them both a lot of weight. They don't necessarily go make an order exactly what the children say and what their views and preferences are, but it really helps the judge frame the case and understand what might be in the best interest of the child, whether it comes from the OCL or a private practitioner.
Great stuff. Okay, let's bring the train into the station, Steph.
All right, so thank you again for everyone's participation, and thank you to our panelists. We hope you found the content helpful, and keep an eye out for a follow-up email with links to helpful resources mentioned in today's presentation that we will be sending out to you tomorrow. So if you do have any questions about our virtual event series or any comments for our team, please feel free to reach out to Shannon. So her email is up on the screen. We do host our virtual event series bi-weekly on Wednesdays at 12 p.m. on a variety of family law topics. Our next presentation will discuss divorce, parenting, and self-help on Wednesday, June 15th at 12 p.m. And we will also be including a full list of our upcoming webinars in that follow-up email if you're interested in learning more. And that's 1 o'clock on the dot. Thank you, everybody, for joining us. And thank you again to our panelists.
Thank you, Steph. You did a fantastic job.
Always,
Thanks, everyone.
Thank you,
Really
Jonathan.
appreciate your time, Golan. Fantastic as always.
Thank you guys for having us, and it was a pleasure being with you here.
It was a lot of
Great
fun.
afternoon, everyone.